So what's on tap for today, folks? Well, it's another reaction video, and I keep getting emails and texts on Twitter, tweets on Twitter saying, "Hey, Dr. Nasir, can you get some more Josh Hawley moments out there, reaction videos?" And so here we have another one today. As I said, we have on tap Josh Hawley grilling Beth Robinson, Judge Beth Robinson, on her very liberal record of basically going against First Amendment rights. So we're going to get into all of that. We appreciate you taking the time to look at our video. And if it's the first time that you've joined the channel, well, guess what, folks? You're watching the Dr. Nasir Shaikh Show. I'm your guest host for today. My name is Dr. Shaikh, and we're going to get to all that in just the next few seconds. But if you haven't already done so, hit the notification bell, like, share, and follow this video. Let's get to my reaction video of Josh Hawley questioning Beth Robinson. We're going to do that right now.
Thank you, Mr. Chairman. Thanks to the nominees for being here. Congratulations on your nomination. Justice Robinson, if I could just start with you, I have to say I'm troubled by your history of compelling individuals to express pro-abortion viewpoints against their religious convictions. I'm talking about the Regal Art Press case. I think Senator Cruz asked you a few questions about it. You represented Linda Paquette in 1994, who demanded that two devout Catholics print custom membership cards for an organization that advocated in favor of abortions. When they declined to do so, citing the teachings of their church, you and your client filed a complaint with the Vermont Human Rights Commission and then a lawsuit. And in your briefs, you argued that their decision not to print those materials was invidious, it was pernicious, and it was akin to racial discrimination, which is quite a claim. I mean, it's really quite a claim. And I have to ask you, why did you feel it was important to leverage the machinery of government? This is a private business. These are two private individuals. Why did you feel it was important to leverage the machinery of government to force these two Catholic business owners to violate their sincerely held religious convictions? Help me understand this.
Thank you.
The reason I'll give you is simple. My reasoning is because these elitists, these progressives, these academics, these judges that want to legislate from the bench, they want to tell us how to live, what to eat, what to wear, what to read, what to write. I mean, what to do, how to think. That's what these guys want to do. What religion? If it's your religious doctrine is wrong. I'll tell you the religious doctrine you need to follow, and it's not yours. That's what these guys do, folks. They want to control every aspect of our lives. Not only aspect of our lives, they want everybody around you, your family, your children, everybody. That's who these people want to control, and that's what this judge wants to do. Let's hear her response.
Senator Hawley, as I indicated with Senator Cruz, that case was 30 years ago, so I apologize if I'm not as precise about all the details, but I can tell you, generally speaking, that we conceded that if the printers had declined to print the materials on account of their opposition to abortion, that there was no basis in law to pursue our claim. The threshold issue in the case is whether that in fact was the facts. My client was a Catholic. She was there to get flyers for Vermont Catholics for Choice printed. She was deeply offended by the suggestion that she wasn't a true Catholic, and that was the reason why the printer wouldn't print the materials. The case never proceeded beyond that stage. We went up to the Supreme Court on what I would call a procedural issue. We went back down and the case settled, and that was the end of it.
Oh, the poor little person, her feelings were hurt. Oh, poor little baby. Her feelings were hurt because two other Catholics called her that she's not a good Catholic. So what? You're allowed to. It's called the First Amendment. You can make your opinions made known. You can tell anybody that they're not a good practicing whatever. Tell anybody you want. Hey, guess what? It's your opinion. If you hurt their feelings, tough crap. But that's not what these people did. She knew exactly what was going on, but that's not what they did. They still went after these two people to try to basically force them to do something against their religiously held beliefs. And not only that, they used the machinery of government. They use the power of the state to go after these people. These people, okay, will do absolutely anything and everything in their power to squash your First Amendment rights, your rights of practicing your faith and your religion, anything that's God-given to you, anything that's given to you by the Constitution, these people want to crush.
Well, I can understand the issue if the government had told your client that she
Exactly.
wasn't a true Catholic or a true Hindu or true whatever, given our First Amendment. But we're talking here about a suit against two private individuals, husband and wife, I believe, Malcolm and Susan Baker, who on the basis of their religious viewpoints said that they couldn't print these cards. And you and your client attempted to leverage the machinery of the state. In fact, you were the ones trying to use the machinery of the state to compel these two private individuals to speak. Now, of course, the Supreme Court has addressed this fact pattern in the Masterpiece Cake Shop case since that time, which concerned compelled speech. In light of Masterpiece Cake Shop, do you acknowledge today that your client would not have the right to compel other individuals to speak in a way that she favors?
Just for everyone to know here, Masterpiece Cake was the case that was just decided right now. Remember that baker? Two people walked in, wanted them to, and their clients, customers of his. They bought all kinds of cakes and pastries or whatever things from his bakery, but they wanted him to bake a special cake for their wedding. Two, I believe it was gay men, wanted to do that. And he said, listen, I can't put that message on a cake. I'll do anything else, but it's my deeply held religious belief that I can't put that signage. You can't force me. And the government of Colorado, they're basically saying, no, we can compel you as an artist, as a writer. I mean, they can make you write, hey, you don't like something? Well, guess what? You've got to write it on a piece of paper and you've got to post. Can you imagine the government coming and telling you that this is what you've got to tweet and it's against your religiously held belief? And they say, no, that doesn't matter. Somebody can come in and say, you know what? You got to put that tweet, 240, whatever characters there are, you got to tweet it out there, even though you don't believe it, even though it's completely against everything you believe, but we're going to force you to do it. Well, that got overturned and, in Colorado. So this is what they talk about the Master Cake case was. But anyways, let's continue.
Senator Hawley, I don't read the Masterpiece Cake decision as altering the Smith holding that neutral laws of general applicability apply without regard to a free exercise defense, nor do I understand the court to have resolved the speech claim. As I read the Masterpiece Cake decision, it turned on the fact that the court concluded that the process in the Colorado Civil Rights Commission evinced hostility toward religion, and it wasn't, in fact, a neutral law of general applicability in that respect.
I think this is an important point. So what you're telling me is your view, understanding the law is that the law can, in fact, compel people of religious faith to speak against their own faith and their own viewpoint. The law can do that. And if it's labeled as neutral, but it just so happens that it compels religious believers to violate their sincerely held religious beliefs, that's okay under the First Amendment. Is that correct? Is your understanding of the law as it currently exists?
No, Senator Hawley, I'm not aware that the U.S. Supreme Court has addressed the nuance of a free exercise claim coupled with a free speech claim, which is what you just described. What I referenced earlier was a straight up free exercise claim, and I think that the U.S. Supreme Court hasn't backed away from Justice Scalia's decision in the Smith case in terms of the applicable law.
So you stand by your representation of this client and all of the arguments that you made, including calling the position of these two Catholics, Malcolm and Susan Baker, invidious, pernicious, and akin to racial discrimination? Do you regret any of that rhetoric?
Senator, I don't remember the context. I haven't looked at that brief in 30 years.
So does the passage of time make it any different? I'll give this to you for the record, and that'll allow you to refresh your memory, but I'm quoting you, invidious, pernicious, akin to racial discrimination. As you sit here, does that not trouble you? You're describing the religious beliefs of practicing Catholic.
Folks, I don't care what it is, 30 years ago, 300 years ago, 3,000 years ago. If you wrote those words, you would remember them. That's not just like tossing something out there and basically saying, Bob Smith went to the store. She used definitive language. And she's saying that I don't really remember because it was 30 years ago. She knows, she remembers, she just doesn't want to admit to it.
Who are citing the teachings of their church. You think that's akin to the Ku Klux Klan?
Senator, the threshold question in the case, which I suspect I will find is what we were addressing in that passage, was whether or not this was discrimination against my client on the basis of her religion.
You were saying that these two Catholics who did not want to provide the speech, you're engaged in the speech your client wanted them to on the basis of their faith, doing so was akin to religious discrimination. Listen, I have to tell you, the last president sent somebody up here to this committee who made that exact argument. It's a Republican who made that exact argument. I voted no. That person didn't get confirmed. I've got profound concerns, Justice Robinson, about your position here. And I have to tell you, the passage of time doesn't do anything to alleviate my concerns. One more question, Mr. Chairman, if I might. Let's shift to criminal law. The Kozłowski case, can you help me understand this case? September term 2017, this is a defendant who was living with his girlfriend and her 6-year-old daughter. The defendant was using box cutters to open boxes. The 6-year-old asks him what he was doing. The defendant held a box cutter to the girl's stomach, told her he would kill her in her sleep, then laughed as the girl ran away. The girl later told her father about the incident, said she was unable to sleep, understandably. This same defendant later convicted of aggravated domestic assault with a deadly weapon. You dissented, saying he shouldn't have been convicted, and you wrote, in part because the blade was covered with plastic, it shouldn't have been considered a real threat, and you went so far as to analogize this to a pillow fight. I've got the case right here. You said this threat in this case is akin to the threat to use a pillow to swat somebody's backside. I have to tell you, this completely baffles me. The threat of a box cutter to a 6-year-old stomach, and the guy says he's gonna kill her, and that's akin to swatting her with a pillow. Help, what am I missing here?
Thank you.
Okay. All right. You know, folks, the problem is, and the sad situation is, that these activist judges, in almost, not in 100% of cases, but almost 99.9, I mean, almost every single case, there might be a few that are out there, but these activist judges, I don't understand what it is about being liberal, being progressive, being moderate, being one of these elitist academics. I don't understand what the problem is, but it seems that they never, ever have the victim's emotions, the victim's feelings, what the victim felt. What about the victim's rights? They never have that. They never talk about that. It's always giving the benefit of the doubt to the villain, to the perpetrator of the crime, to the person who's committed the assault, the robbery, the burglary, the rape, the murder, the selling of the drugs. They're always trying to backpedal and bend over backward, trying to help those guys out. Or I wonder, what can we do to, help them better? What about the victims' rights? It's never shown by these activist judges, never. Let's hear what this idiot judge has to say about this. This unbelievable box cutter to a 6-year-old's abdomen. And she said it's like, because it was plastic and the blade wasn't showing, that it's just like it's doing a pillow fight. I mean, oh my God, how stupid, moronic, idiotic do you have to be?
Senator, I think if the picture in your mind is the box cutter that we use to open boxes in our garage, I would understand your perception of that.
The picture is the one that is in the record because it's in the case. I can see it. It's right here. It's right here. It's a box cutter. There's a blade.
Yeah.
He put that to her stomach.
The blade was completely covered, Senator, and the question of
He
law.
tried to kill her.
The question of law, well, there were two questions. One was the record and what the record showed, and I understand your description of what you understand the record to have showed. I'd have to go back and look more broadly. But the legal question is whether the definition of deadly weapon in Vermont law was satisfied by that implement. The fact that an implement may be used in a deadly way doesn't make it, by definition, a deadly weapon. And so the question involved the very specific nature of that box cutter and the way he used it.
Well, all I can say is I find her position in this case frightening. And the idea, as the father of 3 young children, the idea that somebody puts a box cutter to a young girl's.
It's just absolutely unbelievable, folks. I mean, this is just unbelievable. I mean, how much more liberal do you have to be? This judge is absolute. I mean, this judge, she should not be able to be on the bench unless you absolutely just want to tear the Constitution apart and tear apart the First Amendment. As a recap, initially what she wants to do is compel somebody to go against their religious teaching, their doctrine, their whatever they feel that they're following, their practices. And then she wants to bring the power of the state, the power of the government, to compel you to do something against your will, against your thoughts. And then again, with the case of the person holding the box cutter and the letter of the law saying that because the blade was hidden in the plastic or whatever, it wasn't a weapon that could be used to do harm. I mean, this is unbelievable. Again, siding on the side of the person who's attempting or may perpetrate the crime, or the villain, or the person who's committing the act, instead of on the victim side and thinking about that. This is unbelievable. And as Hawley was saying, she should be nowhere near a bench. The only bench she should be near is a park bench, and that's it. And that's even, I don't even want her near a park bench either, folks. Anyways, we appreciate you watching the show here as much as we brought to you. Josh Hawley, these videos, I just love doing them because he knows, I mean, his questioning is so pinpoint. It's so precise. He goes right in after the person. He has all the information there. He leads them down this path, asks them the questions. And many times he's like incredulous. He's like, explain this to me. Because it just, to a normal person, you're like going, what? It doesn't make any sense at all. So explain it to me, how it made sense to you when he's talking to the witnesses. Anyways, thanks for watching. If you haven't already done so, subscribe to the channel. You're watching the Dr. Nasir Shaikh Show. I was your guest host for today. My name is Dr. Nasir, and I'll leave you with my final thoughts, which are, when you're right, and when you're left, these guys are so wrong. We'll see you again next time, folks. Take care and stay safe.